Welcome back, everybody. This is, I guess, part two, the sequel of last week's episode on the PIPL, People Law, the Personal Information Protection Law. Last time we had Atticus, partner in the Shanghai office, to discuss some of the technicalities of the law. But this episode, we want to focus a little bit more on the practicalities and implementation. And to help us with that, we have Sana Duncan from the London office. And she has been involved in the data space and the GDPR space for, I guess, is it 11 years, Sana? So,
I've been practicing data protection since 2010. Hi.
Well, okay, much longer than than I said. So basically what we want to do today, and of course, if you guys have any questions, put it in the chat, but what we're trying to figure out today is the PIPL, but put it try to glean some information off of the PIPL by looking at the GDPR. So I'll just do some housekeeping real quick. Everybody will get a copy of this presentation that is registered through the Eventbrite, so no need to worry about taking notes. And there's some links here in the presentation that you'll be able to click when you get the PDF of the presentation. This slide was in the last episode, but I just wanted to put this here just to remind everybody that the PIPL goes into effect November 1st, so we're about a month away now. There's the official link to the Chinese version is in the red box, and the unofficial English translation is in the blue box. So if you have any questions about the language, you can feel free to check that out on those links. So basically, what I was going back to earlier, and Sana can help with some of these stories, is I was collecting some of the headlines from some of the penalties and the fines that international companies were receiving for breaching the GDPR. So I was wondering if this could possibly be a look into the future. Will we see similar headlines to this under the PIPL? Sana, do you have any, do any of these headlines kind of stand out amongst any of the others, or in your experience?
I'm so sorry, having a slight technical glitch. Would you mind just repeating that? Can you hear me okay?
Yeah, we can hear you fine.
Oh, good. Sorry, just say that again.
I think Sean just said, yeah, GDPR, there are a lot of big fines in Europe for GDPR. Is this, China, can you just, because I think GDPR, for people who were not working in corporate Europe, like I was in China that whole time, you always wondered why people were so worried about GDPR. I guess when you see these kind of figures, can you just tell us a little bit about how worried were the companies that you've been working with about GDPR?
Yeah, so really worried. Obviously, 4% of a company's annual worldwide turnover is a lot, obviously up to 20 million euros or 4%. And the issue has always been that, is the 4% truly of the whole turnover of a company, or will they just take the company that was in breach or the whole group turnover? It's still not entirely clear. Obviously, we've seen fines recently in the UK for British Airways and Marriott hotels, although they were substantially reduced from the original proposals. So British Airways originally 183 million, eventually was more like 26 million. But the thing is, it's still a lot. I mean, 26 million pounds. And then obviously the French regulator fined Google 50 million euros early on in the GDPR. So we are seeing quite a lot of fines coming up, and also fines that have already been levied.
And what about consumer sentiment? So do European consumers, do they, does this resonate? Because this is headline news here, at least Sean's found some headlines, but one of them here is like 525,000 euros or 450,000 euros. Yeah, there's probably bigger things happening in the world, but this still hits the headlines. Are companies more worried about the fines, or they're more worried about the, repercussions in the market?
I think it's reputational damage, because unfortunately the fines are made public. So when the fines are made public, then naturally it makes the news, everybody hears about it, and that's not great for any business, to be honest, to be in the headlines. Nobody wants that. So even if you can afford the fine, it's the reputational repercussions. And particularly at the moment, a lot of companies have faced penalties on direct marketing, which is in the consumer context. So, you know, sending people unwanted marketing emails or messages, etc. That's been a real issue.
That's what Sean does every day when every time we do one of these webinars.
We all love the spam knot, and it's a real crackdown, especially in the UK, on the sort of marketing messages, and really the key messages, always thinking about what would somebody expect, what would a typical or what would somebody expect you to be collecting their data for and using their data for, and if it's outside the bounds of that, it's unlikely to be legitimate.
Yeah. So just on that, just to close off on this slide, then, so I guess in the PIPL law, you know, it's gone one better than the European one because it's 5%, and also they can even close down the company if you're really naughty. So I guess, you know, it's really got teeth. And I think on that, we might have mentioned it last time, the thing which is interesting is I think the consumer angle, so I don't know if GDPR, in the Chinese law, it will allow consumers, if they feel that people aren't taking care of it, the consumers will have standing to go before the court. Does the GDPR have that concept?
Yes, it does. Yeah. So under the GDPR, company can get fined, individuals can bring claims against the company. And they can seek compensation through the courts. And a lot of what we're seeing now are class action trends. So groups of people bringing claims and somebody, so finding a body that will represent them. And the scary thing at the moment with GDPR is often those people don't even know that a claim is being made on behalf of them. So you could just say, you know, a group of people have been affected and a body can bring a claim on behalf of all those people. So potentially you could have millions of people, and even if they received, say, you know, £500 or £5,000 each, when the numbers are big, that's scary.
We should go after those guys for breaching the GDPR of their claims. Okay, maybe we move on.
All right. So this presentation is basically split into two parts. The first part is analyzing the impact of PIPL and also try to learn some lessons from the GDPR along the way, analyzing the impact on the business. Firstly, data from the products and the services. I think this is like, I guess, the primary concern, right? This is kind of where you start off when you thinking about your data collection. What are my products and services? What are they actually capturing? But it gets a little bit more nuanced, you know. I put this this picture here because your photo bombs can now become data bombs, because, you know, for example, if you have if you're taking pictures of your, I guess, someone who has accepted some or consented to the collection of the data, but you have someone in the background who, you know, is also being captured by that same photograph. You know, there's a lot of like different, I guess, scenarios that a person like me who has no experience really with you know, GDPR and all of the PIPL, how it's going to work, but there could be a lot of I guess more niche and more subtle concerns that people who are now experiencing PIPL, especially if it's for the first time, they might be able to learn a little bit from the GDPR. So maybe start off with Sana first. Sana, you know, there is this concept of anonymization and de-identification of personal data that is highlighted in the PIPL. Before Mark, you can explain a little bit more about what are those terms and what do they mean, and then maybe afterwards Sana can kind of give us a little bit of GDPR content.
Sure. Maybe we have to remember that today we're doing about consumer brands. So before we go into the real weeds on it, I think maybe Sana, because, you know, China's had 1 month of experience with this GDPR type law. Maybe Sana could just say, what were the biggest concerns of consumer-facing brands? Was it like how they collect data on their apps, how they collect, cookies? Is it the card loyalty schemes, all that kind of stuff? Maybe Sana can give us just a bit of a, an overview of what was happening to consumer companies when they first got GDPR.
Yeah, so I think the biggest issue for consumer companies, and I suppose for many companies, but mainly I suppose for consumer companies, was making sure that all the information about what data is collected and used is actually provided to consumers at the point of collection, and making sure that they've read and understood that information. So the GDPR places an obligation, obviously, to provide privacy notices to individuals, telling them how their data is going to be used and for what purposes, how long it's going to be retained, where it's going to be transferred, which third parties it's going to be shared with, all of those things. So first of all, in order to actually provide that information, a company's got to make sure they know the answers to all of those questions. So lots of companies had to carry out really big data mapping exercises throughout their organization to figure out where the data flows were, what was going on, where the data was stored, how it was being used, all of those things. And then to be able to actually provide that information in an intelligible form to individuals and in an easy to understand way as well, because the GDPR requires that any privacy notice has to be designed so that a lay person can understand it, not full of legalese and really difficult to navigate. So a lot of companies have had to come up with solutions on how they can provide a privacy notice that's going to be easy to follow, and they've gone with, for example, layered approaches. So providing a certain amount of detail and then clicking through to more information, and especially on mobile apps, I think that's been quite a challenge, because as you know, you can't read reams and reams, but I think some companies have done, they've done a good job so far from what I see. But that has certainly been a challenge, and something that, and then of course, individuals have extended rights under the GDPR. So if you're a consumer facing business, then potentially you've got, not only can your employees bring or raise or exercise their rights under the GDPR, but so can all of your consumers potentially. So they could ask to access their data, have their data deleted, have their data transferred, all of those things. And in order to be able to meet those requests, organizations actually have to have the systems that can cope with those requests and the resources to be able to meet those requests. And I think that places not only a kind of technical burden on organizations, but also a financial one. And companies have had to grapple with that, especially consumer organizations, because there's more potential for those requests to be raised.
So I think, with the PIPL, everything you said, I think it's all very similar. The right
yes, it is.
to know what's happening with your information, the right to withdraw your consent, the right of portability, and those things. So the issue is it only came out in August, and it you have to be compliant by 1st of November. Or you should be compliant. Probably nobody is compliant with GDPR fully either, but
no, there's a 2-year lead-in for GDPR.
Yeah, 2 years, I think. It was 2 years for GDPR. So what happens, having been also in a company like Deutsche Bank, so you're really seeing it, what kind of time frame was it necessary for consumer companies to get up to speed?
To be honest, I don't think anybody can be 100% compliant. So that's what I usually say to clients. I mean, to achieve 100% compliance would be really difficult, and only a regulator could tell you. Nobody else could really provide you with that kind of certification. But what you can try and do is make sure that your policies and your procedures are up to scratch. And before you can actually sort out your policies and procedures, you need to understand, like I said, what's happening with the data within the organization. So really trying to figure out, where is the data coming from? So what sources? Then where is it going from that point? Where is it stored? Is it stored outside of the jurisdiction? Are the companies or any third parties that you're using, Are you happy with the contracts you have in place? Do they have adequate protections in to protect the data that you are giving to those third parties? So all of those things need to be ironed out, and then you can put in any policies and procedures in place. And then at that point, you may not be 100% compliant, but if there was to be a breach or a regulator was to be involved, then at that point, at least an organization can say, look, we tried, and look, this is what we've got in place. And we have seen in the past under GDPR and under previous data protection laws that where a regulator sees that an organization has actually put in some effort, the fines are much lower and they are more lenient. Where it looks like the organization just didn't care or was completely negligent, then there's more chance of being in serious trouble.
Yeah, but I think on a China perspective, the guys who will be at the forefront of being at risk are the big tech companies, because they deal with so much tech and so much data rather. But I think the other thing is, we've even seen it for the last few years, a lot of apps, like, I don't know how bad the apps are in the West, but, a lot of the apps in China, they were taken out by the CAC, the Cybersecurity Administration, because they were collecting all kinds of things. Like, you download an app, but, it would be secretly using your microphone, accessing your emails. And so I think, if you look at consumer companies, I think that's really going to be the main issue will be your apps and whether you can desegregate the data. Because I can imagine a lot of people just have a funnel, all data goes in there, and that's their client list, but they aren't able to say, okay, this client only wants this kind of consent, or this client wants to withdraw his consent. Oh, I've got to give him back the records on him. I imagine they don't have that. I think many companies wouldn't have that unless they were trying to be GDPR compliant already. But so I think with the data here, this stuff, Sean, about capturing the data, I think these are all hot topics, but might be a little bit beyond us. It might be just worthwhile saying from China, if anything, China is more sensitive than elsewhere about geolocation data. And then I think the anonymization, de-identification, that's a complex area. I don't know if it's really for consumers. I think it's more for like healthcare or things where you have to like statistical. So maybe it's a bit beyond today's chat.
Yeah, let's go to the next slide. So this is possibly something that I think is, I don't know, I'd be interested to hear Sana's thoughts on this in particular about cross-border transfer of data. Of course, from a China perspective, this has always been one of the leading concerns, I guess, for a lot of international technology companies or just consumer companies in operating in China, collecting data on their consumers and then transferring that data overseas back to HQ, possibly to see what are the consumers' wants, what are what is trending, these types of things. Sana, from a GDPR perspective, because this is still something that I think is being kind of previously before PIPL, and you can check out the part 1 of this series on our YouTube channel. But there hasn't been a very clear process on when does cross-border transfer of data actually trigger some event. But now the PIPL does mention a couple different areas where you might need a security assessment, or you might be exempt from a security assessment. So from a GDPR perspective, Sana, does the GDPR have such similar does it address this similarly, or because I'm very interested to learn how they've done it, and possibly if the PIPL, when it comes to implementation, if it might follow suit.
Right, so the data transfers landscape has recently changed in Europe due to the decision last year of Schrems. I don't know if people are familiar with that, but it was all over the news. So this was the issue of transferring data to the US. and it was deemed that the US was not, even the privacy shield that the US had was not a safe mechanism for the transfer of personal data, because it could organizations could potentially pass information on to the US government, and therefore any data coming from Europe via Facebook, etc., was not safe. So that sparked off a massive kind of overhaul of the data transfer system in the EU. And I suppose one of the main mechanisms that is used, and people are most familiar with, are the European standard contractual clauses, which are effectively a set of European Commission approved standard clauses, a data transfer agreement, and the parties enter into it. So the exporting party in the EU and the importing party in the outside the EU enter into this data transfer agreement, and then you can transfer the data to that particular jurisdiction outside the EU. And then recently the EU Commission has come up with a new set of standard contractual clauses, and the idea being is that you can account for the sort of various chains that are formed nowadays, because it's not as simple as just, often there are multiple parties involved in a data transfer. So you might be an organization who is the controller of the data in the UK, for example. You then transfer to a service provider in China. The Chinese service provider onward transfers to other subcontractors elsewhere. Or, you know, and so there are multiple parties involved and chains involved. So now there is a modular approach in those standard contractual clauses, and depending on the transfer scenario, companies have to choose which module of the standard contractual clauses they're going to use. I'm just mentioning the standard contractual clauses because that is the main mechanism that organizations tend to rely on. Of course, there are other options. So if you're in litigation, you can transfer. That's one of the reasons for a legitimate data transfer. Consent is, but that's not really practical, and it's not advised to rely on consent because of all the issues that surround consent. A, it's impractical trying to get consent, especially if you've got a big user base. And secondly, consent has a very high bar these days under the GDPR to meet consent requirements. It has to be informed, it has to be completely separate from any other contractual terms. So lots of things. I won't go into all the nuances now, but in answer to your question, Sean, when the standard contractual clauses were proposed, there was the European Commission said that following Schrems, every organization would have to do what's called like a transfer impact assessment and decide whether the jurisdiction where they are sending the data to has adequate laws to protect the data. And at that point, everybody was absolutely, I mean, even the data protection specialists were thinking, how on earth could we possibly do that? Because it takes, for example, the European Commission has only deemed a handful of countries adequate in terms of data transfer. So, for example, Canada, Japan, a couple of the jurisdictions where you can send data without any agreements, etc. But it took the EU Commission, approximately 5 years to decide whether those countries were adequate or not. So for an organization to have the resources and the finances to be able to, do all the diligence on another country's laws and find out whether, that's a massive job. So now what they've come up with finally in the final sort of text of the model clauses, the standard contractual clauses, is that there's a warranty. And this is, I mention this because it's quite an important point from an EU perspective, which is that if you're transferring data outside the EU, you have to warrant that you consider that the recipient party's laws are sort of not going to contradict what's in the data transfer agreement. So that's quite a big thing. And I'll stop there because that's quite a long answer to your question.
Sana, so just on that, I think, this is interesting because, firstly, I think, I was reading that with this PIPL law, China now is, together with the European Union and the Japanese, I think, were the only ones who had a really comprehensive personal. So is it possible that the European Commission would recognize China as actually having the laws in place? Potentially,
Mark, yes. Like I said, only a handful of countries have received adequacy status. For example, Australia doesn't, and Australia has quite decent data protection laws, similar to what we had pre-GDPR in the UK. You know, there are other countries, you know, that, you know, aren't completely. So, but now with the PIPL, yes, there are a lot of similarities, and there is every possibility that, you know, the EU Commission could decide China's adequate, but I wouldn't imagine that would happen for at least a few years, because I think they'll probably want to see how well it's complied with and what the enforcement looks like.
So I think, yeah, just one other point, and we'll move on because otherwise we'll run out of time. But yeah, one point about this transfer is everybody, and we of course have a Chinese perspective on these things. Everybody's always saying, oh, you have to get these approvals now from China to transfer the information overseas. But I think what we're probably seeing is a lot of companies in Europe were not going in accordance with GDPR because, you know, all of these R&D and collaboration projects, there was information transferring in both directions. So I think now China's just building a similar wall to other countries. And I think digital is so important. That's a normal thing to do. But I think that's perhaps an issue. And yeah, so just one other little point, like with the UK and Brexit, just to show how dynamic it is it true that they've already watered down the GDPR kind of requirements for the UK, and then the UK may not be in that kind of common digital market, I guess?
So they haven't watered the GDPR down as yet. Obviously the UK could deviate potentially. At the moment, we have the same EU GDPR wholesale, and now called the UK GDPR. And of course, the UK did receive adequacy status from the EU earlier this year, which means that any transfers to the UK from the EU are still legitimate, thankfully. And I think the UK would have to be extremely cautious about deviating too much from the GDPR, because it could then obviously lose its adequacy status. And actually, the EU Commission has built in a thing about actually reviewing the UK's position. So it's not a complete, you know, that's it, you've received adequacy forever.
Okay. So I think, Sean, I think the big thing here is that it's cross-border. Let's remember that there is a jurisdiction on both sides of the border. And just the last, I promise, is the last point.
One point, which is a contrast to PIPL, sorry, just before we move on, which is that at the moment, we don't, in Europe and the UK, as long as you rely on one of the GDPR mechanisms for transferring data, you don't have to get specific approval from the regulator to do any transfers.
So it's like Schengen. Once you're in, you can move around freely.
Yeah, as long as you have a something in place, either standard contractual clauses or whatever other mechanism you're going to use.
Yeah, okay. I think the interesting part is the standard contractual clause, because the PIPL does have, does acknowledge this clause, but of course there is no implementation yet. So I do want to get to some of the questions here, and this one seems pretty relevant at this stage. I guess we can first ask Sana. The question is, are we specifically required to give the specific name of the entity that the data is being transferred to? For example, it is going to be transferred to ABC Limited, or can we mention it more generically, like it might be transferred to a service provider or one of our vendors?
Yeah, are you talking about, is this in the context of providing information to individuals where their data is being transferred to? If that's the case, then you don't have to give the specific name. You just need to give the types of service providers. So for example, in your privacy notice, you could say, we may transfer your data to our insurers, to our lawyers, to our marketing services providers, IT services providers. Sometimes I've seen companies do mention specifics, but if you're a massive company using lots of different service providers, that could be tricky to mention every single one. In the context of data transfers, of course, the party has to be specified, obviously, when you're entering into a contract.
Mark, from a PIPL perspective?
I think that sounds all very similar. I mean, I think the only thing is, a lot of people were up in arms that there was no, in the PIPL, there's requirements that you have to have contracts with whoever's processing the data as well. So I think, you know, so I think it'll be what Sana said, but also that you have to actually have it. And we had lots of clients only last year who were asking us to draft these kind of agreements. They didn't have any real agreement in place.
Yeah, I thought that question kind of, it might relate to the standard contractual clauses, which we don't have any insight on from PIPL yet, but possibly we can look towards the GDPR for that. Going back to the consumer issues here, one of the areas that I think might, you know, go under a little bit under the radar, but is probably a treasure trove of information is the customer support team and the after sales teams, because they're actually dealing with, you know, the customers individually and personally. So Mark, there was I put here, you know, under the PIPL, you know, the concept of mass handlers, and we talked a little bit about that on the previous episode, but you know, there is this concept of mass handlers, and it's one of those exceptions, you know, where you might need a security assessment as opposed to maybe using one of those standard contractual clauses or something like that. So maybe you just can just give us a little bit background on, you know, mass handling and how that relates to consumer brands.
Yeah, so I think it's again, you know, the whole concept of the people who'll be more, you know, involved will be the massive companies, you know, and yeah, but China's got a massive population, so they didn't specify what is so a CIO is the critical information infrastructure operator. That also has never been clarified under cybersecurity law. We kind of know what industries, but it's a little bit, you know, indeterminate, which is quite common in Chinese law. But yeah, I was quite confident that very few of our clients would ever be considered a CIO. But now the mass handler, I'm less confident, because the threshold we think will be, well, I'm guessing it'll be either 100,000 people's data or 1 million. The 100,000 is from the automotive data security trial provisions, but also from a gaming, there was like this gaming regulation where they said, if you're doing more than 100,000, you need to get certain registrations. The 1 million is what was for DD. After the DD storm, the CAC said, if you've got more than 1 million people's data points, you need to do a cybersecurity check before you do an offshore listing. So probably somewhere between 100,000 and 1 million will be what the threshold is to be a mass handler. And then you have to undergo that security and all that other rigmarole.
And I think this is a good time to, and I'll ask Sana this, another question from chat. The question here is, if an employee leaks data, which the employer handles, besides the employer being liable for, you know, fines or other penalties, can the employee be personally liable too? You know, I want to bring this up in this slide specifically because, you know, we're talking about customer support, and, you know, these people do touch, you know, more directly a lot of personal information. So Mark, I'll get your opinion on PIPL later, but first I want to hear it from the GDPR because it's more established. So Sana, what is your experience on that?
On whether an employee can be held liable?
Yes.
Yeah, so generally speaking, it's the organization that is responsible for implementing data protection and compliance and ensuring that employees are adequately trained. So an employee can't be held responsible if the organization didn't provide adequate training or adequate policies, etc. So obviously, if, for example, an employee has been trained and then there's some kind of deliberate action on the employee's part, so maybe malicious or intentional hacking or intentional disclosure, unauthorized disclosure or something like that, then an employee can be held responsible. So for example, can go through the company's disciplinary procedures, etc. That would be perfectly legitimate for an employer to then take that employee through the disciplinary procedure and even potentially dismissal. But that the company needs to say that in its staff privacy notice. So all employees need to be aware of what the consequences would be of not following the company's data protection policies, which is the same for any company policies. I guess, that's the kind of thing you set out in an employment contract right at the outset. Yeah.
Mark from PIPL?
Yeah, I don't know. I think that all makes sense to me. I don't think it's so specified, but I don't think I've ever seen an employment contract in China that's dealt with data issues. So that might be something for employee handbooks. But things are often very static, so people don't often update things. But I think everything Sana said just makes common sense that it would also apply here going forward.
I think the PIPL does mention, that there must be trainings and these types of things. But of course, I would assume, malicious acts by employees will probably not be covered by, this.
But I think, the other thing will be, PIPL does talk about the security assessment and the audit and a chief information officer or something, data protection officer or whatever, all those things. But I think for a lot of companies, it must be an advantage for the European companies. They have something in place, and I imagine replicating it in China will be much easier. But equally, if you don't replicate it in China, you're probably going to have an uncomfortable discussion why you're treating European consumers differently from Chinese consumers.
All right, I just want to, maybe I won't spend so much time on this, but of course there's all different types of data that might not be expressly mentioned in the PIPL, but which probably still needs some. Let me just grab the pen here. I was reading, I was putting together the headlines from the previous slide, and they were just pointing out the authorities here. It was the Italian authorities, just really interesting things that I thought, of course, is data, but it's not something that you would probably think of as important data. This is more of a general data. The battery level of your phone. These types of things. So it's a little bit unclear how PIPL will, of course. I'm guessing it's going to be a case-by-case basis, but it would be good to.
But I think this kind of information, it's not about the information. It's about how much they're collecting on you without knowing, and how they use it for the algorithm. And the PIPL, I don't know if GDPR specifically says it, but PIPL says you can't use the algorithmic thing to give a different price. So the remaining battery level, it could well be, if you're like looking for a petrol station or something, if they know that you haven't got much battery life yet, you will be much more keen to get it. Someone else told me there's an algorithm. If you're using an Apple phone, they'll charge you more than if you're using like a Huawei phone or something, just because the idea of that consumer. So I think this stuff here, it's difficult for a human to understand how this information comes together. But with the big data, they're able to build a profile that they know you better than yourself. And that's why I think it's important that PIPL is cracking down on this algorithms which manipulate people without them knowing.
Yeah. I think it's one of those forest for the trees, individually might not, like you said, humans might not understand, but once you start piecing it all together, it kind of, I get, it does make sense in a big data place. But all right, this is the last section, I guess, of the presentation. I want to make sure we get enough time to cover all of these things, and I'll get to all the questions at the appropriate time. So just keep putting it in the chat. Sana, you mentioned before about mapping the data, and I don't think it's a very easy task, considering all of the different types of data that we just talked about in that first section, whether it's coming from the product, whether it's coming from the customer support, or other places, even internally keeping track of your employees' personal data. So can you just give us a little bit of background of what does that process look like?
Yeah, so different companies implement that process differently, obviously, depending on the size and resources. So I can probably give a couple of sides. So for example, Deutsche Bank, obviously being pretty massive, there was a huge exercise undertaken to map data and figure out all the systems, and all the different business areas were responsible for So they had a questionnaire that they had to complete, and they had to figure out all the data that was in the systems that they were responsible for, where it was coming from, where it was going to, where it was stored, all that kind of stuff. They had to complete these questionnaires, and then that data was then input into a bespoke system, which was specifically for documenting data mapping exercises. Now, of course, not every organization has that capacity, and even so, I have to say it was hugely complicated and not particularly, you know, it wasn't a case of now we know where all our data is. Even then, it was like maybe a 70% solution, you know. So it's a very difficult exercise, especially if you're a big organization. So I think the best you can do really is trying to speak to all the different teams within the business and asking them individually to figure out for their own area, and at least having some sort of either, I know, spreadsheet or system that documents as much as possible, really. And in particular, what service providers are being used. If you've got systems that you're using, are they hosted or maintained by any third parties? If so, are there contracts in place? Is any data being transferred outside the jurisdiction? So those are the main things, and like I said, the way to try and do it really is just to try and get the buy-in from each team, which can be difficult, but obviously if you can get a bunch of people together and actually really work with them and make them understand the consequences of, you know, not knowing, then hopefully you can get buy-in. And of course the management has to be fully on board, so you have to get your sort of, you know, very senior people in the organization to actually want to do this, and then cascade it down.
Yeah. Mark, I expect something similar probably happening.
Yeah, I just think, yeah, just personal experience, not as a data or even a lawyer, but I always think one of the things I've noticed that if we do an M&A deal, the IT transition is always one of the most difficult, painful things, because nobody understands what the IT guys are doing and they never want to change anything. It's always very complicated. So I think these things, it's not just pressing a button, you know. I don't know how to solve it, but you'll have to get your IT team. It's not easy to do.
Yeah, and so I just add, some companies do it by having an audit done, so actually having a data protection audit carried out and getting like an external party in. Again, obviously that depends on budgets and things, but it's one way to try and establish what's going on.
So we talked a little bit about, you know, transferring data, and maybe Mark, this is probably something I think, like you mentioned before, you know, this is something I guess that's going to be quite important for a lot of international companies who are processing, handling data in China, and that is the localization of a China either data team or R&D center, something like that. So, you know, what are some? We put a couple broad principles here for localization, but how should an international company who is quite used to, you know, maybe, you know, even pre-GDPR, to transferring data a little bit more freely, should they be, you know, what options should they be considering?
Well, I think, because we want to really hone in on the consumer aspect. So I guess really the biggest one there will be, a lot of people have been collecting data from Chinese consumers what do you call it, offshore, you know, so people would consent and do it. And I guess many people who do cross-border e-commerce kind of consumer sales or these other kind of sales, they never thought they were, you know, subject to any laws. But now they will be subject to those laws, because it explicitly says if you're dealing with China or you're doing business with the Chinese consumers, then you're within it. So I think that'll be an issue. Will they be the ones that they'll get attacked? Yeah, probably not. In the first thing. First, there's two issues perhaps. One is there'll have to be like a domestic responsible person for data, and maybe Sana in a second can just explain how that works in GDPR. Yeah, we've got a similar concept with cosmetics in China. If you're importing cosmetics, you have to have somebody in China in case, you know, everybody's hair falls out, that they can hold somebody responsible. So that's that's got to be a big issue. And then I think secondly, the the big tech companies who many of these consumer brands are reliant upon, they will act like a watchdog. So it's similar with Tmall. Within 24 hours, you can get a pirate whatever site closed down on Tmall, because Tmall had that big thing a few years ago. So they've got really a zero tolerance for piracy or counterfeit goods, or at least they will react as quickly as you tell them. So I think there'll be a lot of self-policing by the big tech companies, and you may need to show that you're compliant to let them to continue to sell your product, because they don't want to fight with the cybersecurity guys, So I don't know, maybe Sana, could you tell us a little bit about how it works and what kind of liability these overseas people, so let's say if a Chinese company was looking for somebody within the EU to act as the
So you need to appoint what's called a GDPR representative. If, for example, you are based in, if you're based outside the EU, if you're a company outside the EU and you are selling goods or services to people in the EU, or monitoring their behavior in any way. So for example, if you're conducting any profiling or analytics, placing cookies, targeted advertising, that kind of thing, if you're doing that on EU-based individuals and you're based outside the EU, and if you don't have an establishment in the EU, so you don't have an office, an entity within the EU, then you have to appoint what's called a GDPR representative. So that is somebody, or could be a firm of solicitors could act as a GDPR representative, or you could have an individual who acts as a GDPR representative, and the idea being that they are the point of contact for those EU individuals. So if those EU individuals have any concerns about how their data is being used, any questions, if they want to exercise their rights, they need to have a point of contact within the EU that they can actually get a hold of and raise any of those things. So now that now that Britain's no longer in the EU, unfortunately for companies operating in the EU and the UK, you now have to have a UK GDPR representative and an EU one. So it's quite annoying, but that's just the way it is. And I'm pretty sure that the concept is similar under PIPL. And actually, recently we saw a fine. There was a company in the Netherlands called it was one of those concepts called locate family, where I believe you can sort of look for your family members or other friends, etc. And they didn't appoint a GDPR representative, and they were operating in the EU, and eventually they got fined €500,000 just earlier this year in the summer.
I think Sean had that on his headlines. So where was that company? That was a US company, or who were they?
I believe it was a Canadian company.
So even a company that, because you said Canada is one of the few companies GDPR recognizes.
Canada is an approved jurisdiction for data transfers. So if you're transferring data outside of the EU to Canada, then that's okay, and you don't need to implement any mechanisms. But it doesn't mean that if you're operating from Canada, and you are operating in the EU without an establishment, that you don't need to appoint a GDPR rep.
And this GDPR rep, do they have to fulfill any specific requirements? Can it be just a man of straw, or just
no, it needs to be somebody that understands data protection and the GDPR. So
So that's high risk then, I guess. What are companies doing? A Chinese company, because we got obviously Chinese companies on today. Are Chinese companies doing this for the UK or the EU, or they're just being lucky so far?
I hope they are. I would like to think that they are. Obviously, I don't know, because, for example, we've had approaches recently from more from Australia, actually, and from some other companies where they've got an EU representative and they now need a UK one as well. So we've seen some of that occurring, but I'm not sure how seriously the GDPR representative has been, that obligation, how seriously organizations have taken it. But I guess now, since this fine, people will take it.
Who gets fined? it was obviously, if there was a breach, what kind of liability does that GDPR representative have? Because I assumed in China it could be very big responsibility if there's a breach or something. Are they somehow safe, or what happens?
Yeah, they are fairly safe unless they've been, because I think in this actually Locate Family case, they tried to argue that it was the representative's fault, but it wasn't, that they didn't actually have one and they were trying to get out of it. But the thing is that they are fairly safe in under EU law, so they're a bit like data protection officers. I wouldn't describe it as a protected status, but ultimately it will be the company that's liable if something goes wrong, not the GDPR representative who's liable.
And with that GDPR, I mean, because I think this is very important for a lot of the people on today, the consumer brands, or even the software as a service type people who are operating offshore into China, or the education guys. I saw one of them on there as well. So that kind of GDPR representative, because I think China will, follow what the European is. Will that person have to be really involved in the data, things? Does he or she actually have to know what's happening, or it's just a point of contact?
The processing operations of the company, but they are kind of on the periphery, so they're not leading in any way in the company's data protection sort of day-to-day operations. They need to understand what data the company processes and how it does, etc. And they need to be able to field any questions, but they're almost the go-between. So they're not
like a liaison point.
Party. They're the liaison point.
Okay, great.
So their job is to, if a data subject needs to contact somebody, they contact them. Then it will be the GDPR representative's job to then field that to the relevant part of the organization, etc.
Okay, well, that makes it easy. I thought these guys might end up going to jail. So hopefully China is similar.
Yeah, hopefully PIPL follows. But Sana, you mentioned this before when we were talking about data mapping. Assembling a team to kind of, I guess, coordinating the efforts. You said you wanted to perhaps send a questionnaire out to each team, but of course, behind those questionnaires must be a unified front of the willing who are collecting and analyzing all of the responses. So so you're behind the data mapping. What does it take, and what do companies do to put together a task force, a team together who is going to handle the data mapping and all of these other implementation issues?
So like I said, in my experience, it usually has to come right from the top first. So there has to be this messaging that, look, this is an exercise where we need to do, we have to do, and everybody has to cooperate. And then obviously you then gather within either maybe team leaders, or it's not always the team leaders actually that know exactly what's happening, but you ask each team to maybe choose who they want to be involved in this audit exercise. And then obviously, yes, you're right, somebody has to be responsible. And usually that's if there is an in-house legal team or an in-house data protection person, they would be responsible for maybe designing the questionnaire and also sort of leading that exercise. It's not easy, but it takes a lot of involvement and a lot of time.
I want to get through a couple of these slides because we don't have so much time left. And this gets directly to a few of the questions here in the chat, actually. And this is concept of third-party compliance, your vendors or, anybody else that you're using to either transfer data or just, course of regular business. How do you stay on top of that they are compliant with either the GDPR or PIPL, and all the data that they're collecting is not going to affect you? So maybe Sana, you can just give us a little bit background on
So it's really important, I guess, that when you appoint any third party, you've got to do enough due diligence to make sure that that third party is reputable and has sufficient data protection procedures and security in place. I think security is the biggest thing, because it's all well and good having contracts, but if a company doesn't have good data security, then there's likely to be a breach, and then, you know, things will go wrong from there. So it's about the practical and the common sense stuff sometimes, or actually not sometimes, all of the time, but, you know, not just looking at the paperwork. And when you are appointing a service provider, obviously there are big service providers, so the likes of Microsoft, Amazon, you know, when you're having cloud services, often they will have accreditations, they will have ISO certifications, they will have other, you know, they're massive companies, they know what GDPR requires, so they should be geared up to meet those requirements. But obviously the more sort of medium-sized, smaller companies that your vendors, those are the ones, I'm not saying they're not compliant, because they will be, a lot of them are, but you just need to make sure you're checking and doing all of that due diligence at the outset, and then putting the relevant provisions in the contracts, and also looking at liability. So if something does go wrong, what's the liability going to be? You know, what can you get? What's going to happen? Who's going to deal with a breach? Apportioning all those responsibilities and things, really important to iron out at the beginning. And actually the Marriott hotels, that breach was, it happened because Marriott acquired a hotel chain called Starwood. And at the time it acquired Starwood, it didn't realize that Starwood had actually suffered a data breach 2 years previously, and the data breach had gone undetected. They bought Starwood, they didn't realize the breach had happened. They carried on using the Starwood systems, which were compromised. And in 2018, it all came out that actually these systems were compromised as early as 2014. And Marriott ended up being responsible for the fine, because they had bought Starwood and now it was their problem. So it's really important to do due diligence at the outset, and also if you're acquiring any businesses or companies, etc., making sure that data protection is, you know, really looked at properly.
Mark, do you think that under the PIPL, Chinese companies will probably do something similar? And I think this goes back to your point of possibly that, you know, the big tech, the big Chinese tech companies, like Sana mentioned, the cloud companies, we could talk about Ali Cloud, for example, that they would probably feel that they want to make sure that their third parties or their clients are compliant. So it kind of goes a little bit both ways then, in a sense.
Well, I think Sana had some very good points, and I think we didn't think of some of them for a contract we did a few months ago. So maybe I have to revisit that contract and put some of those things in there.
All right, just 2 more slides here and 2 more minutes left. Thanks for staying awake, everybody. An eternal feedback system, and I think maybe Sana, because you have a little bit more experience with the actual implementation for GDPR, and that's, you know, the 2 years buildup it took for that, you know, as opposed to the PIPL, where things are moving a little bit more quicker. You know, like we were talking about different teams having to, you know, do audits and questionnaires and analyzing how they are collecting their team's data. But I would assume that, and maybe you can, you know, share your insight, but I would assume a lot of the teams probably have very similar problems. So maybe one of the efficiencies that, you know, especially if the PIPL is coming next month, might be to just have like an internal feedback system where we can address similar issues across multiple teams. I don't know if this is something that, you know, when companies were getting ready for the GDPR, if this was something that they were utilizing.
Yeah, so of course, like depending on how, you know, what your organization is like, if you can get a group that meets regularly, that discusses as they're going along, nothing like it. But often, you know, to get that cohesion, especially in larger organizations, isn't easy. It just really depends on every company's structure and kind of, you know, how they operate and the culture of the company as well. So yeah, I mean, the more collaboration is good in anything, and it would certainly work in the data protection sphere as well, but it just depends.
I put at the last paragraph here that, and this might be more relevant for PIPL, is the, even though some of the issues might overlap, some of the solutions might be a little bit nuanced. And Mark mentioned earlier, de-identification and anonymization. This is a little bit more in the weeds, but important to keep some of these details front of mind when it does come time to implement. And this is the last slide here, and that is, keeping track of all of the legislative updates. Mark, maybe we'll just end off with you, but the PIPL is kind of a sweeping piece of legislation, and you've seen a lot of the laws come during your time in China. How does one keep track of something as important as the PIPL, especially, I would guess, during the first year or so, when a lot of the gaps are being filled with respect to some of the more ambiguous language?
So I think, they will have to be filled. Like you say, the template contracts haven't been released. There's lots of information. But I think, one could perhaps rely on the GDPR as a good guide. So if it works there, of course, there'll be some differences. It's probably not a bad bet to start with that, rather than wait for everything to be finished. Because I think if you ever wait for everything to be fully clear, you'll always be running catch up, because, they will probably issue implementing measure draft regulations. But, in China, you don't always wait until something's officially published to start action. So I think that's one issue. I think here, what I think is interesting is, within our group, we've been pretty busy. Most of our clients are normally foreign invested enterprises, but to date, I think we've had 12 Chinese companies reach out to us to support them on their PIPL transition or, audit or something. But we've only had two foreign companies two German companies who were very big companies in China, and engineering type companies who have a lot of cross-border and that. And then, I think it was like one American company asked a question. So really, I think the foreign invested enterprises aren't really engaging. Some people say that they've got a team working on it in London or somewhere else. I don't know if it's really true. So I think it may. I don't think the Chinese normally just on 1st November they're going to hit everybody, but it gives them a tool to hit you. The consumers being involved will make it difficult for consumer companies. And I think for most consumer companies, you'd have to worry a bit if the big, the cloud, if you're a SaaS provider or if you're selling on Tmall Global, you have to worry that the Chinese company that might be at higher risk might just close down your shop, or CIC might delete your app.
Yeah. So, and I put the last point here, of course, subscribe to The Art of Law, because we will be doing some more of this as well. I don't want to take up everybody's time. Everyone will get a copy of this presentation. And like the last one, I also decided to put in the last few slides here on the back comparison between the PIPL and the GDPR. So you will also be able to take a look at that. Thank you, Mark. Thank you, Sana, for sharing all of your insight. If anyone has any questions, I will put Sana and Mark into the emails that when I send the copy of the presentation, and feel free to reach out to them. Thanks a lot for joining, everybody.
Thanks, Sean.
Thanks,
Thank
Sean.
you.